Order. Would everyone ensure that all electronic devices are turned off or switched to the silent mode? Tea and coffee are not allowed in the committee room. We are continuing line-by-line consideration of the Terminally Ill Adults End of Life Bill. I remind members that interventions should be short and raise points of clarification or questions. They should not be speeches in and of themselves. Members who do wish to give a speech should bob and to continue to do so throughout the debate in which they wish to take part until they are called. And when members say you, they are referring to the chair. You should not be used to refer to each other. The debate should come through the chair. We continue the debate on Amendment 480 to Clause 23 in the name of Danny Kruger, with which it will be convenient to consider Amendments 483, 484, 441, 481, New Clause 22, New Clause 23 and Clause 23 stand part. Could members indicate if they wish to speak? I call Lewis Atkinson.
Thank you, Chair. It's a pleasure to serve under you this morning, and fortified as I am now with a little touch of breakfast. I just want to open my comments on this set of amendments by reiterating, I think, the point I made at an earlier point around the respect and importance that I think it is to respect people's beliefs in healthcare and the contribution that people of different faiths, beliefs, positions, no matter where they come from, in terms of activities under this Act. And you know, I accept and recognise that Amendment 480 from the Honourable Member for East Wiltshire is an important job at strengthening those provisions. I will obviously want to hear what the Minister says and note the comments from the Honourable Lady, the sponsoring member, but I would want to see that sort of expansion in the final bill as it goes to the House. And while if it's not maybe the right exact form of words today, I would repeat the offer that the Honourable Lady has made from my point of view to work across the divide, as it were, to make sure that such provisions are included. I think it's helpful when we're discussing these things, and you know, I've perhaps had the benefit of an overnight reflection. I feel like last night we got somewhat muddled around some of the objections on conscience, particularly when we go beyond the individual. So I think 480 or the equivalent, it very clearly deals with the individuals and no one having any obligation to carry out acts that would offend their conscience in the provision of these services. So I think we can broadly agree on those. I think the remainder of the debate, however, got rather muddled between organisations providing assistance under this Act and the location of at which the final act may take place of an assisted death. And I think those are importantly different. So I also feel, in terms of organisations providing assistance, I think I just want to reset what I think is a common sense of how this will act in practice. So I think the Honourable Lady Member for Reigate made the point that hospices shouldn't be no obligations themselves as organisations to provide specific services, and I agree with her on that. I think the powers that are set out under Clause 32, which we will come on to debate, I'm sure, at some point, in terms of the Secretary of State making arrangements for the provision of these services, will operate in a way, in the way that they do elsewhere across the health service. That an NHS organisation or another organisation will say, this is the set of services that we provide as an organisation. And I see nothing in this Act that compels them to do anything other than that. In the same way that healthcare organisations up and down the land now make decisions about what is appropriate for them to deliver based on the skills, the expertise, the demand, whether they think they're well placed to provide that care. So I agree with the Honourable Lady. I don't, however, it doesn't follow to me that some of the amendments proposed are required to enforce that principle. This is not, as I understand it, going to be because it is legal, because it is permissible, every organisation or every individual practising healthcare professional will be able to say, you know, on my own bat, I'm going to participate in this, regardless of what my employer believes, etc. Not least for the fact of clinical governance and regulation. You know, there is existing a strong body of healthcare regulation around the acts and services that are provided, overseen currently by the CQC. We do not need to reinvent that regime. So I do want to reassure members, I think, that the idea that I think is entirely appropriate for hospices or other providers of palliative care to be considering whether they will want to participate in this should the Act pass. And I imagine we will get to a situation where some will and some won't. And I think that is absolutely appropriate. And clearly, particularly for end-of-life cases, a patient will likely make choices on the back of that. I'm aware in my own area of some end-of-life providers actively considering whether this is something that they will do. Equally, I'm aware that there are others who think this will not be for us. And I think we heard in evidence, didn't we, that in Australia there are some providers of palliative care who are providing an integrated sort of holistic care, and this is one option among a number of others. There will be other providers who do not do that. I think that so I think the amendment. I think 481 around that allows an employer to part A of which suggests that an employer has the power to veto an employee doing an act on their time, as it were, is totally moot. It's not necessary because, you know, in the healthcare environments I've worked in, a doctor may practice elsewhere doing their own thing, but while they're employed in a certain NHS trust to do an NHS service, they can't suddenly decide to do something else. Yes, I will give it.
Rebecca Paul.
I thank the honourable member for his very powerful speech on this. So, in terms of the amendment I've tabled, it's only to ensure that the employee is performing their services. In the example you give, if someone is working in an NHS clinic, that they comply with the policy of that clinic. It doesn't restrict them doing, as you said, other things in their own time. And I think the wording of the amendment is clear on that. And I think I talked about that to the Honourable Lady yesterday, and that it refers to that employer. And it's that piece that makes it clear that it's just whilst that employee is performing their services for them. It's not
I entirely thank the Honourable Lady for her intervention, and I agree with her. That is what the wording says. But my point is, it's moot. She states herself there that to prevent an employee going against the policies of the employer, well, that power already exists. No healthcare professional goes and says, oh, well, you know what, I'm a doctor, and the fact that I'm employed today by such and such a trust, I'm going to do a set of procedures that or practices that I want. So I do think that is moot. But the point that I come on to is, I think part B is deeply problematic of the amendment. So while, you know, on the face of it, A, I have no issue with, because I think it's moot and unnecessary. B, I think, is deeply problematic. I think it cuts across employment law protections by talking about selection when hiring employees, with a reference to the Equality Act, where, as others have referenced, it's not clear what the protected characteristics we're talking about here. But more deeply than this, if we accept that there is going to be a mixed set of provision, I would argue, and I think in this committee we've, in a small way, shown this, there is some benefit. We shouldn't get to a position where every medic of a certain viewpoint works for one organisation and every healthcare professional of a different viewpoint on assisted dying works for another. And I just think you know, that's not saying by any stretch that people should be forced, organisations would be forced to offer assisted dying. Clearly they would not. But at the end of this, if this passes into law, I want a society that has this, that is relatively at peace with this in healthcare, recognising the ability for people to conscientiously object as individuals, as we've absolutely set out, But the idea we set up a dichotomy from the start where, well, you know, essentially, if you're a medic, where you decide to work is determined by what your views are on such and such a procedure, I think is not a road that we should be encouraging. And I do have serious concerns about Part B of 481 in terms of the employment law elements, etc. So that's why I can't support that. I'm going to move on, though, now to... Sorry, yes, I'll give it a
Rebecca.
I thank the Honourable Member for that. It's simply to prevent a discrimination case being taken. So, for example, let's take another example. There may be a rape refuge providing services to women that have suffered sexual abuse, and it may be appropriate in that instance to only hire women to support those domestic abuse survivors in order to prevent a discrimination claim. When hiring, you have to rely on the Equality Act and the exemptions carved out. All this is saying is that that same exemption would apply in this instance when a hospice or clinic is employing. It's just to avoid those issues down the way.
Lewis Atkinson.
I don't... I'm afraid I can't agree with her on that. And I think that the situation that I set out before, where a hospice, for example, makes an organisational decision that they do not wish to provide assisted dying services, I think is entirely legitimate in the bill as drafted. I don't want them to be able to... I don't think they should screen which of my applicants are, you know, have got a certain view. That would be legal under this amendment. I don't accept that that's the case. I think the example she gives is rather different because it relates to a particular protected characteristic, and I think I'm not the expert in this area. Maybe colleagues would help me, but in specific services. But I'm going to move on. I'm going to move on because I'm aware we've started slightly late, and I'm not sure we're going to add anything on that. So moving on in terms of this distinction between providing assistance and the location in which people may self-administer an assisted death. I think that is a fundamental distinction, and I think the Honourable Gentleman from East Wiltshire's amendments and speech somewhat overlapped those two, if I may. So, having established that for example, a hospice would be under no obligation to provide, it is not the case that an individual would be able to turn up, I think, and say, well, your staff must help me do this. I think that is just clearly not the case. That is, however, different to, I think, the situation where someone is living in their own home, and they decide that in their own home, in their own private home, which may include the room within a care home or within sheltered accommodation, etc., that they want their healthcare team to come and carry out entirely lawful and appropriate activities as set out under this Act. And therefore I cannot agree with new clause 22, because people are legally residents. They're registered to vote. They have, in some cases, in some warden, for example, provided accommodation, I think a colleague gave the example of yesterday, they've got a lease. Now, it's not a landlord in absentia, and I know the Honourable Member has provided an opt-out for those situations, but there is a warden situation, a supported housing situation. And we would not accept, I think, operators or owners in those situations policing what lawful activities should happen in someone's own home within that environment. I think that is entirely different, and I think the Honourable Gentleman will allow it to come back in a minute. That he sketches out around everyone must be involved. Of course, there will be no obligation whatsoever on any staff of that establishment, home, to participate in an ancillary or otherwise manner. But in a private residence, in someone's room, in a care home, etc., that we cannot allow, I don't think, that to be prohibited. But I'm happy to...
Danny Kruger.
I'm very grateful to him for giving way. He's making a very helpful and intelligent speech, as always. So I appreciate the distinction he's trying to draw. There's lots to say, and I'll respond more when I wind up. I just wonder whether he would think it would be an acceptable condition of a lease, or whatever the living arrangement is for a resident to come into one of these sheltered accommodation or these shared places, for the operator to specify that no assisted dying shall be performed in that premises, and that to be a condition of residents coming to live there. Would he regard that as an acceptable condition that the operator should include in any contract with residents?
Lewis Atkinson.
My instinct is no, it wouldn't, because if this legislation passes, there's a lawful choice for someone to, I know the gentleman may not characterise it as healthcare, but the services around healthcare and end of life, and we would not be accepting such stipulations on other acts related to healthcare. I think, listen, again, I think I can see a sketch that some may choose to draw, where I think someone mentioned a religious institution supported housing. Again, I think the reality of the situation is people do not go out of their way to offend, and people try and live, I think, in my experience, in harmony with those around them. I do not, there is not going to be people, if people are clear that they wish to actively explore this as an option, they are not going to choose, I would suggest. It'll be uncomfortable for the individual themselves to choose to spend their last days in a place where others around them in that community are ideologically opposed to their choice. But they absolutely have the legal right to do so. So I hope that helps the Honourable Gentleman. I'm happy to give it
I'm very grateful to I mean, having also thought about it overnight, I do think there is a freedom of association argument here, that if you have an organisation of, say, a Roman Catholic organisation that is designed just for Roman Catholics to stay or participate, or a home for retired priests, whatever it might be, or a Jewish organisation that's just for Jewish residents, I could see that, but that's not a service that is general enough to the public. And my concern about this, and I wondered if he'd offer his view, is that could we see a situation where Hampshire Hospitals Foundation Trust, the Board of Trustees, has a majority of people who have a strong religious conviction, who vote that there shall not be this service provided across the three hospitals that the Foundation Trust manages? Now, if this has been drawn tightly to say, there's a freedom of association argument here, then I could see it. Having said that, of course, there's no institutional objection power in law for abortion. People just don't offer it because they don't have the staff to offer it. And it feels to me as if that's what the Honourable Gentleman is pointing to.
Lewis Atkinson.
I think that's entirely right. And I think the response of public bodies, such as NHS trusts, that he asks, is a slightly different issue, if I may. I wouldn't obviously want to speak for government or imagine what the Secretary of State may say, but to me it would be inconceivable for a quasi-independent public body to decide on a vote of some local governors to not, in principle, offer citizens choices that are enshrined in law. So I think that is a slightly different option, but I'm grateful for the point that he's making. So I think I am wrapping up, Chair. Just to come back to the member for East Wiltshire, I think he said yesterday, he made this sketch that if someone chooses to have an assisted death, then everyone is part of it in the care home or etc. I think it fundamentally misunderstands, and it is. I will go for misunderstands rather than doubting any intentions, but some would see that as scaremongering. This is not. No one's asking for the right to do this in a communal area, where staff or neighbours are forced to observe or participate in any way, but where people live in their own homes, and people at the end of life have rights and dignity around their own homes, whether that's in a care home or private residence. We absolutely cannot deny them, I don't think, the options to access options at the end of life as set out in this bill, and therefore I cannot support NC 22 Yes, I will give way.
On that point,
Rachel Hopkins.
does my friend agree with me that with regards to patient confidentiality, that it's highly unlikely that residents of such a care home would even be aware?
Lewis Atkins.
I think that's entirely possible. Clearly, it is up for the individual concerned to discuss how far they wish to share with neighbours, friends in the home or indeed elsewhere. But we absolutely cannot get to a situation where someone's intentions at end of life are, as a policy default, broadcast within a certain radius. I think the Honourable Lady is entirely right and helpful in making that point. Yes, of course.
I'm great with my honourable friend of the way. I appreciate he's close to be winding up. And I don't want to go over old ground. We certainly not in the later hours yesterday on my amendment 533. But if I may, this is sort of the issue that my amendment was seeking to look to resolve. Certainly not on the face of the bill, but I'm sure our colleagues on the front bench there will be doing something about it. But I think, as my honourable gentleman alludes to, in some situations it's not as, I think, black and white in terms of the sense of place where this stuff, where we'll be able to carry out these procedures. Because I fully appreciate what my honourable friend is saying, that people do deserve the right, if they choose to end their own lives in their own home, they should be able to do that. But I do think in some situations, some examples, as been alluded to today, further thought will need to be undertaken, I think, by the government as to this issue around place. I think it's really, really important.
I'm grateful for my honourable friend. And of course, in considering the offer of any health or care-related activity, the appropriateness and suitability of that place is always in people's minds. And clearly that varies. And as I mentioned yesterday, we already have a licensing regime with the CQC that specifically licenses places for particular activity. So I think he's right. But I just don't think we should... This is a normal part of decision-making around the provision of health services, and I don't think we should try and constrain it in primary legislation through these amendments, though recognising, as I started, that we absolutely have to enshrine the right of individual conscience objections, which I think the Honourable Gentleman was trying to do on 480, and I hope we can do through some route in the bill. Thank you, Chair.
Now, Shaw.
Thank you, Chair. I'm wanting to speak to amendments from Member for York Central 441 and 484. I want to move them and also speak in support of new clause 23, moved by the Honourable Member for Reigate. Amendment 441 would change clause 23 so that there would be, to quote the exact language, no obligation on any care home or hospice regulated by the Care Quality Commission or the Care Inspectorate Wales to permit the provision of assistance under this Act on their premises. I think it's clear that assistance in this context means the act of administering lethal drugs. That is the sense that the word is used in, for example, clause 18 of the bill. Amendment 484 tightens this restriction somewhat to say there is no obligation on any of the hospices to permit any activity closely related to the provision of assistance under this Act. New clause 23 also applies to all regulated care homes, hospices in England and Wales. It provides that none of these organisations can, I will quote from the clause's language, be subject to any detriment by a public authority as a result of A, providing assistance in accordance with this Act, or B, permitting such assistance to take place on their premises. The new clause goes on to say that no public authority can make its funding for a regulated care home or hospice dependent on their agreeing to provide assisted dying or agreeing to allow assisted dying to take place on their premises. All these amendments are aiming at the same goal, to making sure that this bill does not harm this country's hospices. We have heard from many witnesses how much hospices do in providing palliative care and end-of-life care. Caring for people who are close to the end of life is difficult and vital work. The people who do this on our behalf include some of the very best people that we have in our society. All of us should hold ourselves responsible for not making the task of hospices more difficult. The idea that this bill might do that is something that has been raised with us by people working in this country's hospices. Hospice UK takes a neutral position on whether assisted dying should be legal in England and Wales. but it is important to note it has at the same time set out some very clear positions on how the bill should and should not affect hospices. On funding, Hospice UK's written evidence number TIAB 36 has this to say. If assisted dying is legalised and becomes part of the health service, steps should also be taken to ensure there is no financial detriment to any hospice, whatever their positioning on the practice. I agree strongly with this argument for several reasons. The hospice sector in this country receives a mixture of private charitable money, including donations and the proceeds of charity shops, fundraising events and public funds. Like the rest of the population, the people who run and work in hospices have a mixture of views on assisted dying. We do know that many of them have strong objections on various grounds to assisted dying. If public funds were made dependent upon hospices agreeing to assisted dying taking place, then we would see several things happen, and all of them would be bad. Dr. Sarah Cox, a palliative care doctor who is president of the Association of Palliative Care, said this in evidence to the committee on January 28, and I quote, "I am also concerned about our palliative care workforce, which we know is already in crisis. 83% of our members told the Royal College of Physicians in 2023 that they had staffing gaps, and more than 50% were unable to take leave because of those staffing gaps." Dr. Cox went on, 43% said that if assisted dying was implemented within their organisation, they would have to leave. This has huge impact on palliative care in terms of its potential to develop both our funding and our workforce, who are really concerned about this. Toby Porter, Chief Executive Hospice UK, had this to say to us in evidence on 29th of January, quoting from Hansard. "If hospices were involved in assisted dying, there is a theoretical risk that that would just reinforce an inaccurate perception about hospice and palliative care. The myth that you are helped along your way by doctors in hospices and hospitals, that's one risk. More briefly, the second risk relates to the duty of care. What do you need for hospice and palliative care services? You need adequate resourcing, which means staff and financing. In terms of staff, the real fragility in the hospital and palliative care sector is a shortage of clinical staff. That is shared nationally with the NHS and other healthcare providers." Toby Porter also mentioned the evidence of Dr. Cox. Mr. Porter told us, "You will know from Sarah Cox's evidence that the majority of palliative care consultants hold views against assisted dying, many of them very strongly." He continued, "If the consultants felt, for example, that they could not keep their distance from assisted dying in a 12-bed hospice unit in the way they could do in an 800-bed hospital, you could very easily see that if this was not done properly and the consultant deserted the hospice sector, you could no longer offer the specialist care that is so important to the Minister, the NHS and every health and social care provider." There are many people in this country who would be entirely willing to enter a care home or a hospice if they thought they might end up receiving assisted dying in that place. But there are other people who already fear that they might be pressured into taking assisted dying if they enter palliative care. They may well be wrong to fear this, but they do. We heard evidence on this point from Dr. Jamila Hussain. She said to this committee when giving evidence on the 29th of January, and I quote from Hansard, "I work predominantly with an ethnically diverse population. I have gone into those communities and I have spoken to them about this bill. What they say overwhelmingly to me is we're scared. We're really fearful that this is going to result in a disproportionate impact on our community. We have seen that through COVID and we're so scared. We already don't access your services. We're really worried that we won't want to access them anymore and we won't want to access the hospitals." That fear, Chair, will only grow if we use public funds to oblige hospices to permit assisted dying on their premises. Hospices should be able to say quite clearly to their patients that they do not allow assisted dying to take place on their premises. The dedicated professionals who work in hospices and who deeply object to people being helped to die with lethal drugs must also be protected. They should also be free from having to work on premises where something that they might disagree with. I anticipate some honourable members may argue that Amendment 484 might draw its restrictions too tightly. They might argue that this amendment would mean that a doctor working on a hospice premises or making a visit to a patient in a hospice could not have the preliminary discussion about assisted death with that person. Both these measures relate to, and I want to be really clear about this, the provision of assistance under this bill. Provision of assistance is the phrase used throughout the bill, not to refer to the preliminary discussion, nor the interviews with doctors, nor with the panel process. It is used to refer to that part of the process which is when the person takes lethal drugs with a doctor present. There are clear and moral arguments and clear practical arguments for saying that hospices and care homes should be allowed not to allow people to take lethal drugs on their premises. There are equal arguments why that they should not face losing public funding for refusing to allow assisted death on their premises. One of the things that strikes me from the debate that was had last night and today was about the idea that would we be discriminating, would people be discriminating? The Honourable Member for Sunderland just talked about the issue of provision of staffing. So my experience, and I just wanted to speak to that slightly, Chair, because my experience is when we do employ people, say for example in refuges, those are generally general occupational qualifications which we use. So we use that legislation to recruit those people because of the nature of the business. But I think there is a further debate to be had, and I don't have all the answers. But what I am concerned about is those hospices that have charitable functions or charitable aims under the Charities Commission, which have a set of beliefs. I am also concerned that So I'll give you an example. It's an example in terms of the principle is the same. We don't say vegan restaurants are discriminating against meat eaters because they're not providing steak. We don't say that. That's a service that they decide to offer. And I think that is the principle for me that we need to be looking at. And there's also something about the conversations we've had throughout this debate are very much about autonomy, autonomy, autonomy. What about those people who want to have their autonomy in how to run their businesses? Whether that be it from a religious perspective, whether that be it from an ethical perspective, whether that be it from a charities, fundraising perspective. Some people, I know, it's the month of Ramadan, and one of the obligations on me as a Muslim is one of my 5 pillars is giving zakat, which is charity. Zakat is charity, has very, very clear outline of where that zakat can go and what needs it meets. So for educational purposes or other purposes, but it can't, there are different sets of charity that I can give for other purposes, but that is specified for me. Happy to give way.
Honourable Lady, and this is obviously a difficult and sensitive area, but for example, does she think that a women's refuge run by a Catholic foundation should be allowed to evict a woman who wants or has an abortion?
Now, Sean.
I absolutely do not think that, because that is the law in terms of her abortion rights. And but I also think that that woman, when she's going into a refuge, that refuge will make clear that that she may choose not to. It's about empowering both sides. It's about saying to somebody, so for example, if we take that very argument, and I'm really grateful for his intervention, if we take that very argument and we have somebody who wants to pursue assisted death, and they want to go into a place, and they know that that organisation doesn't, and they are informed that that organisation doesn't sign up to provide an assisted death, then it comes back to the issue that the member rightfully raised, the member for Sunderland, when he said we don't deliberately go out to offend people. We don't deliberately, as a people, we don't go out, if I may just finish my point, we don't deliberately go out. As somebody in that space, and I can't imagine being there, but I'm trying to understand it, is would we want to then access that service because their religious belief differs with the assisted dying, with assisted dying as a principle? Happy to give way.
Dr. Marie.
Just so I'm clear, the Honourable Lady is saying that where there is a situation where a young woman who is escaping domestic abuse, does not know at that point she is pregnant as a result of that domestic abuse, and wants to go to a domestic violence space close to her home so that her children can carry on going to school, but once she is there, finds out she's pregnant by the abuser, that the Honourable Lady thinks that that's acceptable.
Which bit's acceptable, sorry?
That the Domestic Violence Protection Centre or home can refuse that lady from staying there because she's latterly discovered that she's pregnant as a result of the abuse and wants to seek an abortion.
Yeah, I thank the Honourable Member. Absolutely not. I'd be horrified if that was the case, because there isn't. I cannot imagine any refuge with any religious beliefs turning away a woman who is in this country. I know we've had cutbacks and we don't have the access, but any refuge turning away a woman who is in that, as she has described, I'd be absolutely horrified.
Will she give way?
I'll be happy to give way and I'll come back.
So the reason that I asked that question, I'm glad to hear her answer, is that in an analogous situation where there may be another woman who suffers from breast cancer, who is allergic to opioids and does not necessarily know that when she enters the care home, her cancer reaches such a stage of terminality, but she cannot pursue palliative options because of her allergy to opioids. So assisted dying is the only option for her to die with dignity and not in great discomfort. The analogy applies in that situation because under the Honourable Lady's scenario, she would not be able to pursue an assisted death in that care home.
Now, I thank the Honourable Member, and she makes a really important point, and I absolutely hear what she's saying. I'm not sure if she was going into that hospice or care home when she was pursuing assisted death. I'm not sure how that would work, but can I? Yeah, happy to give way just for time.
Just to clarify, in my very clear example, and it's a real life example, it's an example that would reflect the experiences of someone that was in this committee yesterday, where that person entered that space and had a terminal condition, but discovered whilst that hospice or care home was trying to find methods to palliate that she was allergic to opioids. Therefore, they would not be able to palliate her condition such that she was in a care home which made her comfortable, which was near her family. But in your scenario, she would not be able to choose assisted death because that care home had a blanket policy against it, discriminating against this young woman's situation where she had an allergy to opioids that meant she could not be palliated.
I thank the Honourable Member for her intervention, and it gives me a lot to think about, and that's why I said I genuinely don't have the answers, which is why I want this discussion for me to enable me to make that choice of whether I'm going to support this amendment. But I really want to explore this further because I think it's really important. I'll give the Honourable Member away, and I'll give the
Rebecca Ball. I thank the Honourable Member for allowing me to intervene. The conversation has moved on a little, but I was just going to make the point that the amendments actually that I tabled focus very much on the rights of the employer in terms of with respect to what they expect from their staff. So I wonder if it would be helpful to explore that a little more.
I thank the Honourable Lady for her intervention, and if we are talking about employers, then I'm hoping that this scenario that the Honourable Member has referred to wouldn't happen, because we're talking about employers and employees, not necessarily people who are accessing the service as service users. Happy to give way to the Honourable Gentleman.
Well, Danny Kruger.
Great, there's much to get into, and I'll try and respond a bit more when I speak again. But just to the Honourable Lady's scenario, I mean, without revisiting the whole question of palliative care, I'm afraid the strong advice that I have from palliative care professionals is that it's not accurate to say that somebody's pain cannot be palliated. It might well be that there is a difficulty with particular opioids, but there are other palliative care options available to everybody. No palliative care doctor ever says there's nothing they can do. So I do just. Well, again, we've been over the whole question about palliative care and alternatives to assisted suicide. Nevertheless, I do want to challenge that scenario. And to the suggestion that there's a comparison with an abortion service, no one is suggesting that in the case of a woman who goes into a refuge, who discovers she is pregnant and wants to have a termination, that she's obliged to somehow have the termination on the premises of the refuge, which doesn't believe in abortion. That's not a scenario that could happen, because that's not how abortion operates. What we are suggesting here is that in the scenario where somebody arrives in a care home or a hospice which doesn't want to facilitate an assisted suicide, they would not be able to do that there. There's no objection to them having the belief in, what desire for having assisted suicide. The point is to protect the institution. And I do recognise the difficulty the Honourable Lady raises with that specific case. Nevertheless, the alternative to it is to have a blanket permission for any resident of any care home or hospice to insist that they can receive an assisted death in that home, despite what the rest of the community and the management of that care home might state, and indeed what the patient themselves might have signed a contract specifying that they will not seek an assisted death in that home. So anyway, there's much more to discuss. I hope that's helped the Honourable Lady.
Nasha?
I thank the Honourable Member, and it is really, very helpful. I just want to come back to the issue of opioids. As somebody who's a chronic pain sufferer, my understanding is I have a choice for whether I'm taking opioids or whether I'm taking other medication as well. So it's not always, when people are allergic to opioids, they can actually access other medication potentially for pain relief. In coming to my closing remarks, Chair.
Honourable friend, wait.
Yeah, absolutely.
Great.
Jack Abbott.
I appreciate my honourable friends giving away a number of times at this point. I think a lot of the focus about this discussion in the last few minutes has been around if the care home has already made it clear they don't support the process of assisted dying, and therefore you join knowing that if you're entering that care home. There is a clear scenario, though, where some care homes may change their position over time. So someone may be in a care home for many, many years, for example, and then their care home may change their position and say, actually, now we don't support assisted dying. So in that scenario, actually, people will have gone into that setting thinking that the care home, for example, supports that process. And so while I'm very sympathetic to the issue of place, as has been made clear, I think this has real ramifications. I don't think, again, it's that black and white saying, well, this care home's already had a set position. Some care homes or other settings may change their positions over time, even when those residents are in situ for a long time. So I think this is kind of the big problem with this particular clause is, actually, again, this isn't as straightforward as perhaps some conversation we alluded to today.
I thank my honourable friend for his intervention, and he makes a very valid point that it isn't, and that's why people are tabling amendments, and that's why we're having this discussion to iron this out, to make sure that we nail this in terms of making it as safe as possible. What I will say is that there are laws in our country which do protect people's religious views. We do have the Equalities Act. We do have, those are there for reasons. And I do think that I would not want to see, I would not want to see hospices not funded because they take a position not to be, so speaking back to all the amendments. B, I would also, from an employer's perspective, I appreciate the scenario and I will come back to it, from an employer's perspective, if an employer is recruiting with their values, it's a bit like, oh God, we're in politics, all of us. We all sign up to a particular view of politics. That doesn't, when we recruit our staff, we actually put on our applications, on our information, we would like you to adhere, have a belief in our value system. That's not discriminating against somebody who has a different value system, is what my response will be. I'm happy to response to give way.
Lewis Atkinson.
I thank you for giving way, and I just want to nail this employer point of recruitment. So I think we've talked about that no organisation will be obliged to provide services. So in exactly the same way as we are under abortion. So the example I would give is, okay, provider of women's services saying, we're not providing abortion, but in addition to that, we're going to ask staff members that we're recruiting whether you believe that we should have, that it's ever legal for abortion to take place. That's exactly the same test of belief on a different medical procedure that I think she's proposing in this instance.
That's not what I'm... Sorry, I thank the honourable friend for his intervention, and that's not what I'm saying here. I'm not saying... I am saying very, very clearly, when we recruit people to any job, we ask them to have the values that we have as an organisation. We do that, but in terms of somebody I think, so I'm not convinced that's the point I'm trying to make, and I appreciate his intervention, but that's certainly not the point I'm trying to make. And in coming back to the scenario, I can't imagine, again, coming back to the Honourable Member for Sunderland, I can't imagine anybody, even from a religious point, genuinely trying to, even if they've changed their position, is treating somebody in that way, because we don't do that. We just don't do that.
Well,
it's not something we do. Yeah,
I appreciate that, but I think, as the Honourable Lady has said a number of times over the last few weeks, unfortunately, some of these things do happen.
Yeah, they do.
I mean, in all of our casework, I'm sure I've had people with guide dogs say, well, we've been refused certain services, including taxis, even though that's a civil offence, because we have a guide dog with them. We've said a number of times that there are flaws in every single system. So I appreciate that we want to adopt a really goodwill attitude. I'm sure the vast majority of settings across the country would operate under that basis, but we do know that in certain circumstances that isn't always the case. So that's why, if we put anything on the face of the bill, it's got to have real clarity and not sort of unintended consequences as well.
I thank the Honourable Friend, and he's absolutely right that we do need to clarify this, and we do need to. So I think it comes back for me, in summing up, Chair, it comes back to some of the questions that I have for the Minister, and I'm just wondering whether he is able to answer some of this, especially given that we have made lots of arguments in this, the amendments that have been tabled, certainly from the government, by the proposer, has been about giving statutory duty to the Secretary of State. In that instance, perhaps the Secretary of State will be able to clarify and make this watertight under using regulations. So it would be interesting to know if we've had an assessment on the impact of provision of healthcare in the assisted death were permitted, either a hospital, a hospice or a care home, and whether he'd be happy to share that assessment with the committee. So, for example, if we're going back to palliative care specialists who are saying X amount of people would no longer want to be involved, and we could have a real risk of an exodus of specialists from hospices, then we need to know whether there's been an assessment on that, and perhaps the government can help us to understand that, because that is a real concern from palliative care specialists. And whether he's had, certainly given that he mentioned this week he went to a hospice earlier, and whether we've had any discussions with Care England, care homes, about allowing this process to happen in actual care homes themselves. And how are these concerns being assessed of clinical staff about allowing an assisted death in their healthcare facility, and if any concerns have been put forward to him in that regard, and how many staff have indicated that they will need to leave the NHS or care provider or hospice if an assisted death were mandated on their premises. And there is the other element of a charity commission, coming back to beliefs about whether we've spoken to the Charities Commission about the impact this could have on charitable bodies if they were pressurised into changing their charitable aims because of this bill. Would they be protected from providing assisted death because of their charitable views? So I think this debate for me this morning has raised more questions than it has answers, and I think there's much more discussion to be had, and I'm happy to listen to the member for East Wiltshire, because I can then intervene and maybe probe more. Thank you.
Minister.
Thank you very much, Chair, and it's...
Sorry, apologise. Danny Kruger?
Okay.
Well, I can speak either to press my amendment, or I can speak now.
No, it's at the end.
Okay, all right.
Minister.
Thank you very much, Chair. It's a pleasure to serve under your chairship this morning, even though it was a little bit later than originally planned. Amendment 480 is intended to extend the category of those who are protected from being obligated to participate in the provision of assisted dying under Clause 23 from registered medical practitioners, registered nurses and registered pharmacists or pharmacy technicians to all individuals. The amendment also seeks to clarify what an individual can refuse to do under Clause 23, subsection 1, by setting out a non-exhaustive list of activity under the bill which an individual would not be obligated to participate in. The amendment also specifies that the ability not to participate in the provision of assisted dying does not override any duty to signpost someone to information about assisted dying, to perform clerical, secretarial or ancillary acts, or to perform life-saving acts or grave injury-saving acts. This amendment would introduce significant legal uncertainty. It may mean that a person who had opted in to providing services under the bill could refuse to continue or use clause 23 as a justification not to perform their duties as described in the bill. For example, they may use this amendment as justification for not checking eligibility criteria, discussing prognosis or palliative care options or other requirements under the bill. Amendment 480 may also conflict with other provisions. It states that no individual is under any duty to be involved directly or indirectly in the provision of assistance in accordance with this bill. This may mean that, for example, while under the bill doctors are required to notify a cancellation, this amendment would allow the doctor to refuse to do things under the bill, even if they have opted in to provide assisted dying services. So it's not clear which provision would take precedence. This could allow the doctor to decline to notify of a cancellation through arguing that they are relying on clause 23, subsection 1. Amendment 483 is intended to extend the range of activities which registered medical practitioners or other health professionals are not under any obligation to provide, to include activities that are closely related to the provision of assistance under 23(1) of the bill. Amendment 484 is intended to expand the protection from being subject to a detriment by an employer at 23(2) to include where a registered medical practitioner or health professional refuses to participate in activity closely related to the provision of assistance. As drafted, the term activity closely related to the provision of assistance is not defined, and this could create uncertainty as to what types of activity this is intended to cover. On 441, as currently drafted, the bill does not specify where the provision of assistance may or may not take place. Amendment 441 would prevent there being any obligation on a care home or hospice which is regulated by the Care Quality Commission, CQC, or the Care Inspectorate Wales, CIW, to permit the provision of assistance to be carried out on their premises. The effect of this proposed amendment is that it may limit the places where assistance could be provided. It may thereby reduce access to an assisted death for those residing within a care home or hospice, if the care home or hospice did not wish to allow an assisted death to be provided on their premises. This may preclude some people from accessing services under this bill if they were near the end of life and may be impeded from leaving their usual place of residence. It may therefore result in inconsistent treatment for patients when seeking to access an assisted death. This could potentially engage a person's rights under Article 8 of the ECHR, right to respect for private and family life. Turning now to 481, this amendment has two parts. The first part aims to ensure that employees cannot participate in the assisted dying process in the course of their employment if their employer has chosen not to participate in assisted dying. The effect of this is that it may limit the places where assistance would be provided, and may result in inconsistent treatment for patients when seeking to access an assisted death. This could engage a person's rights under Article 8 of the ECHR, right to respect for private and family life. Regarding the second part, the explanatory note suggests that this seeks to ensure that employers may require employees to provide or not to provide assisted dying under Schedule 9 of the Equality Act. Schedule 9 of the Equality Act enables an employer to specify that having a protected characteristic is a requirement of the job, where having the characteristic is crucial to the post and a proportionate means of achieving a legitimate aim. The ability to specify occupational requirements is conferred by Schedule 9 of the Equality Act, and reference to it in this amendment does not have any additional effect. Turning now to new clause 22. The purpose of this amendment is to provide the owners or occupiers of premises that they would not be obligated to permit the self-administration of an approved substance on their premises. This right to refuse does not extend to a person who has an interest in the land, but who is not occupying or operating on those premises, such as a landlord. It is unclear if the term premises would apply to a residential property, care home, or hospice. As a result, this amendment may mean that someone who is terminally ill and is residing in, for example, a care home or hospice, could be required to leave that care home or hospice in order to receive assistance under the bill, if the care home or hospice owner does not wish to allow assisted dying on their premises. This could engage a person's rights under Article 8 of the ECHR, right to respect for private and family life.
Will my honourable friend give way?
I will give way.
Jack Abbott.
Appreciate my honourable friend giving way. I think another one of the examples raised by the honourable gentleman over there was around hospitals as well and under certain trusts because of the word premises. In the government's view, would hospitals and other such facilities beyond hospices and care homes also be included within this new clause?
I thank him for that intervention. I think, as I was saying, it is unclear what the scope of the term premises is. Is it residential property, care home, hospice, and indeed hospital? I could have added to that list. So that's one of the challenges around the way in which the amendment is drafted. It's not clear what its scope is in terms of the definition of premises.
Will you give way?
Danny Cruz.
We're going to get on to the question of the NHS provision, but surely in the case of the NHS, if it's a decision of Parliament and indeed of the Secretary of State that assisted suicide should be provided through the NHS, then that's what will happen. I mean, it might be that there might be some trusts that have some sort of autonomy to the extent that they can decline to deliver certain services. But surely, if it's the case that this is a healthcare treatment, and if it's to be regulated in that way, and if it's to be set out as something that shall be provided by the NHS, surely hospitals will not be in a position to decline to deliver if they are indeed NHS hospitals. The purpose of these amendments is to protect private and charitable providers. Do you agree?
Minister.
Yeah, I agree with the sentiment of his intervention. The challenge is just the way in which the amendment is drafted could well lead to unintended consequences because it's not clear what the scope is, and if you're not clear on what the scope is, then the scope could potentially be exponential, and that's the challenge that we face with the drafting. Turning to new clause 23, Chair, this amendment proposes a new clause that would prevent regulated care homes and hospices from facing any detrimental consequences for not providing or permitting assistance in accordance with this Act. This also means that their funding must not be conditional on them providing or permitting such assistance to take place on their premises. As a result, a person who is terminally ill and is residing in a care home or hospice could be asked or required to leave that care home or hospice in order to receive assistance under the bill if that care home or hospice provider does not wish to allow assisted dying on their premises. In such circumstances, the care home or hospice provider would not be able to be placed in any detriment as a result of any action or decision taken. This could potentially engage a person's right under Article 8 of the ECHR. Further, public authorities would not be able to persuade care homes or hospices to provide or permit assistance to take places on their premises by offering additional funding if they agree to do so. Equally, if a public authority gives unconditional funding to care homes or hospice providers in recognition of their agreement to provide or permit assistance to be provided on their premises, and that provider later decides not to provide or permit the assistance and spends the funding on other matters, the public authority would not be able to recover the funding if it were given unconditionally. Turning now to clause stand part. This clause sets out that no registered medical practitioner or other health professional would be under any duty to participate in the provision of assistance in accordance with the bill. It also sets out that employees cannot be subject to any detriment by their employer for exercising their right to either participate or not participate in the provision of assistance in accordance with the bill. Further amendment to this clause will be required at the port stage to ensure that the opt-out in clause 23.1 and the employment protections in clause 23.2 work effectively alongside the duties imposed on health professionals in other provisions of the bill as amended in committee. I hope those observations were helpful to the committee. Thank you, Chair.
Kim Ledbetter.
Thank you very much, Chair, and thank you for stepping into the breach this morning to save us. I will speak to the clause itself and then the amendments that have been grouped with it. So, as we know, clause 23 of the bill provides that there will be no obligation to provide assistance for medical practitioners and health professionals as set out in the assisted dying process. We know that doctors and other health professionals hold a variety of views on assisted dying. As a significant number are in support of what this bill sets out to do, and the experience from other jurisdictions is that that number increases once it's seen to be working safely and effectively in practice. But others, of course, would object to being involved at any stage, and I'm very respectful of this. This bill is about giving terminally ill people choice and autonomy, but it's absolutely right that this principle of autonomy is extended to registered medical practitioners and health professionals, and indeed others. As such, I'll now move on to Amendment 480. And I absolutely agree with the intention behind the amendment, that nobody should be under any duty to be involved with the provision of assistance in accordance with the Act. I think there's actually consensus across the committee that this should be the case. But I do have concerns about how the amendment is drafted, the lack of clarity around being directly or indirectly involved in the provision of assistance in accordance with the Act, and the framing of the selective list of activities which are referred to in particular. I fear this could have unintended consequences and an impact on continuity of care. And I take on board the comments of the Minister around the significant legal uncertainty this creates. So therefore I can't support the amendment as drafted, but as I've said, I'm very happy to work with the member to consider an alternative amendment which would better achieve the aim of ensuring that there's no obligation for anyone to take part in the assisted dying process. If I come on to the what I think has been a really good, powerful debate actually about institutional opt-outs. Just on a point that was made by the Honourable Gentleman for East Wiltshire earlier on, he said that he didn't think an abortion could take place within a women's refuge. My understanding is that medical pills and drugs that can be given to a woman to have an abortion at home are often taken to their place of residence. So I think that's not strictly true. Amendments 441 and 481, as well as new clauses 22 and 23, amount to what is understood, as I've said, as institutional opt-out, which sounds like a really simple principle, but I think as our discussions have shown, it's actually not. And international experience shows this. Different jurisdictions around the world have different approaches to this, and we should take the opportunity to learn from their experience. Research on the impact of institutional objections in the Australian state of Victoria shows there are considerable harms that can come with the ability of institutions to opt out. Supportive staff and medical personnel have been prevented from discussing the assisted dying process, and in some cases have been denied access to their patients. The delivery of legally authorised substances has been blocked, and the taking of the substances has been banned. As a result, which institution a person was in changed their ability to exercise their legal right to an assisted death, and some were blocked from doing so. One relative of a person who had chosen an assisted death was quoted in the study as saying that institutional objections were a significant challenge that created a whole lot of stress on what was her loved one's last day. She said, "I will always remember with great sadness for me that the last few precious hours on Mum's last day were mostly filled with stress and distress, having to scurry around moving her out of her so-called home." We should not lose sight of the fact that the overwhelming majority of people requesting an assisted death will already be receiving palliative and/or hospice care, although we know many choose to die at home. So I'm very sensitive to the fact that people who run institutions where the assisted dying process might be accessed may hold very sincere and deeply felt views. It doesn't feel right that were the law to change, people in charge of institutional policy could deny the choice of an assisted death to the terminally ill patients in their care because of those views. I'm particularly concerned about Amendment 441 with reference to care homes. As I said yesterday, many terminally ill people want to spend their final weeks and days at home. That is where they choose to die. If a patient is living in a care home, that is their home. They may have been living there for a number of years before becoming ill. Can it be right to ask them to leave their home if they choose to have an assisted death? I've also got concerns that have been raised by colleagues around the concept of shared ownership and sheltered accommodation, as well as limited access in rural areas. Chair, these are really sensitive issues, and there are a range of views across the various professions involved in end-of-life care. Hospice UK recognises this, which is why their formal position represents their members' differing views by having no collective view. They recognise that staff, volunteers and hospice trustees will look at the implications of the bill in a variety of ways, and I really think we should give them the time and space to do so, rather than dictating what they should or shouldn't do through this bill. We've probably all got hospices in our constituencies, in our local area where we visit, and we've got a good relationship, and we've probably all got family and friends who've benefited from the care of those amazing places. I know I have. And that dialogue for me, at a local level, is actually really important, and I think that's almost as important as what goes into this legislation. Of course.
I welcome obviously that sentiment is absolutely right, that we should be working with hospices and letting them set their own policy, which of course is the purpose of the amendment. But does she acknowledge that the Minister has just said that there will be human rights claims if there is any attempt by a hospice to prevent assisted dying taking place on their premises? So they can have all the consultations and conversations they want, but unless we specify on the bill that they are allowed to opt out, they're going to be forced to do it.
Well, I mean, he makes a very, very good point. I am aware of the Minister's comments. I think this is part of the discussion as we take it forward, and I think that is why this debate is really powerful. And in their written evidence, the trustees at Willowburn Hospice, based here in the UK, told us, our mission is to deliver hospice care of the highest standard to our patients and those important to them. We also believe that we should support and enable people to make the choices that matter to them. They say they haven't decided their position on assisted dying and remain open-minded about possible future actions. They say we believe this stance is in the best interest of our patients and their families and reflects the wishes of our community. I welcome this open-minded approach and their commitment to putting care, compassion and dignity at the heart of everything they do. So I think, contrary to what the Honourable Gentleman for East Wiltshire has said, this isn't a black and white picture as he's painted, and I would agree with the Honourable Gentleman for Ipswich on that regard. Colleagues may remember the evidence given to the committee by the CEO of Hospice UK, Toby Porter. Mr Porter clarified for us that institutions do not function in the same way as individuals when it comes to conscience influencing decisions. He told us there is this idea that your individual opinion guides everything, but with a hospice charity the opposite is true. As many members will know because of their own work as trustees, the trustees and leadership of a hospice team are required to put personal opinion and interest to one side and always act in the best interest of the charity's beneficiaries, who are the population. It's also important to remember that international experience shows that up to 30 to 40% of patients who sign up to the assisted dying process ultimately do not access it. Palliative care may meet their needs, or they may simply change their mind. But we also know the reassurance and the comfort that the choice of an assisted death provides, alongside other treatment and care, is really important to them. And I don't believe this reassurance should be denied to some people because of the institution they happen to be in. Of course.
Okay, Malton.
I'm grateful to her, and she's outlining the issues very effectively. No one, of course, is saying that anybody who works at the hospice that may object has to participate. They may say, we just don't, nobody here will assist. But it feels to me, given that, as we've talked about, place is important, and to a certain extent I have a rights as a tenant in a place that I'm resident, that what the Honourable Gentleman is proposing is actual active prevention of somebody being able to access this in a place that they choose. And that feels to me the wrong balance. And I wondered if that's broadly where she's heading.
Kim Ledbetter.
Thank you, Chair. I thank him for his intervention. I think he makes a very important point. It's the word that we have used a lot, or maybe not enough in some respects, is choice. And I think that's really important for individuals, but I also think it's really important for institutions as well. Whereas putting an institutional opt-out on the face of the bill would risk creating confusion and potentially distress for patients and their loved ones, and indeed for staff or volunteers. And of course, I will.
Rebecca Paul.
I thank the Honourable Lady for giving way. Does the Honourable Lady have any concerns around what this position would mean for the end-of-life workforce? I know we are here to make law, but I think we can't ignore the practical consequences of end-of-life care as a result if we don't have this carve-out. We could potentially lose a lot of wonderful, great people who work in end-of-life care who just feel that they are not able to participate if the hospice can't specify.
Kim Ledbetter.
She's absolutely right, Chair, to acknowledge the wonderful workforce that we have working in end-of-life care, but I would also point to the fact that there are a range of views within that workforce. But also remember, there is individual opt-out. Nobody has to be involved in this process if they don't want to be. And that is very clear within the bill as it stands, and hopefully working together we can make that even clearer if needed. As I was just about to come on to, doctors and health professionals already have the ability to opt out for any reason under the bill, wherever they work. Finally, yes, sure.
Now, John.
I just want to understand, because one of the things that hasn't been mentioned is the issue of pharmacies. Would they have the opt-out ability?
It's a very good point. My understanding is, the Minister might correct me, that health professionals currently are within the definition, pharmacists are within the definition of health professionals, but if they aren't, that is an important point that would be made by making the change to ensure that nobody is under any duty. But I will definitely check that. Finally, Mr Porter also said, hospices evolved out of the community. They exist because communities wanted better deaths. In the end, it is the job of institutions to evolve to fit the values and laws of society as they evolve, rather than vice versa. Chair, we know the polling around assisted dying shows a significant amount of public support for a change in the law, which is one of the main reasons we're here discussing the issue today. The latest figures from the British Social Attitudes Survey, published just this week by the National Centre for Social Research, show support at 79% is unchanged or slightly up on a decade ago. So whilst I cannot support these amendments, I think this is a really important debate, and I think we've conducted ourselves extremely well over the last 24 hours. And I think it's important that we continue that debate respectfully and sensitively. Thank you, Chair.
Danny Kruger.
Thank you, Chair. We're very grateful for you rescuing us as well. Thank you, and my thanks to the Honourable Lady. It's nice to be commended for our good conduct. So I'm grateful to that. And actually, it has been a very, very interesting debate, and I thank all honourable members for participating. And I appreciate we have made some progress in understanding each other and potentially improving the bill, though I regret the lack of support from the front bench opposite for the amendments I've tabled. Let me just refresh memories on the purpose of of my amendments. The sponsor has introduced amendments to clauses 24 and 25, which we're going to come to, which keep the phrase "providing assistance to a person in accordance with this Act," but to add to it these two other phrases: performing any other function under that Act, and also assisting a person seeking to end their own life in accordance with the Act. So these amendments expand the protection from criminal and civil liability and mean that performing any other function under this Act and assisting a person seeking to end their own life in connection with the doing of anything under the Act are both protected from criminal and civil liability. But she has not tabled a similar amendment to Clause 23. And there's a very real risk, as the BMA, the Royal College of Pharmacists, the Royal College of Nurses, as I mentioned earlier yesterday, all warned the protection of the Conscience Clause is limited solely to the final Act, rather than to all functions under the Act. And I appreciate the Honourable Lady expresses a commitment to try and ensure that we do cover everybody and all appropriate actions and activities that take place. But I do suggest that that's what my amendment does. In terms of the objections to it, I mean, I appreciate sudden interest in precision in drafting. I do remind. Every time that those on our side of this debate raise detail particular points, we're told that the spirit of the text is clear and we'll sort that out later, and that'll come to guidance, and shouldn't be nitpicking and embroidering and so on. Anyway, I appreciate this attention to detail, and I want to respond to some of the points. I mean, the Minister, I'm afraid to say, I think made a, with respect, pretty tendentious suggestion that a doctor could opt into assisted dying, take part in some of the procedures, but then suddenly decide to neglect performing others, and that would therefore not be negligent. I cannot conceive any court or tribunal conceding that it would not be negligent to fulfil the obligations under the Act once the procedure has begun, and once that doctor has made commitments and indeed undertaken activities already to progress an assisted dying case. The Honourable Member for Luton South objected on the grounds that the amendment might give a gardener or cleaner the right to opt out. I mean, the clause 1B, subsection B of the amendment, actually makes it clear that ancillary activities are not protected by the Conscience Clause. So I'm afraid the gardener is not off the hook. The gardener still has to mow the lawn under this amendment. Now, I recognise the drafting might not be perfect, and I do emphasise the PBL guide to making legislation makes it clear that government should not object to backbench amendments on drafting grounds. So, if there are issues with particular phrasing that cause the government or the sponsor concern, that's something that can be addressed subsequently. So I regret if the Minister is using drafting issues to justify refusal to support these amendments. On the issue of new clause 22 and the issue of premises, which we've discussed very interestingly, a couple of objections have been raised. First is one of these kind of shared ownership schemes, which we're all familiar with, particularly for elderly people. And the answer is simple. I mean, the corporate owner under a shared ownership scheme is not in occupation. So being in occupation has a particular meaning in land law, and it is not the case here that a tenant genuinely in occupation of their own premises could somehow be denied their right to have an assisted death in their own home because of the freehold arrangement of the premises they occupy. I mean, I'm grateful for the indication that members have given, particularly my right honourable friend, that there may well be circumstances in which it is appropriate for a particular premises to opt out of the obligation to facilitate assisted dying, and therefore to give a particular institution the right to deny permission for assisted death. And I'll come on further points, but I'll give way first.
Just to clarify my remarks, I wasn't necessarily saying that they should have the right to deny, but by default they would, if they were effectively a closed community that was discriminating in favour of like-minded individuals, a home for retired Catholic priests, for example. By default, it would be somewhere that was unlikely to offer those services. I mean, the other point to ask, I mean, if he were to give this, if I'm in a hospice and I'm in my bed in my last and I have visitors coming to see me, and one of those visitors is the doctor that's coming to administer to me, I'm not quite sure how that would be prevented unless they're willing to be a wrestling match at the door of my room.
Danny Kruger.
I'm grateful. Well, actually, under the terms of the amendment, it would be an offence for the owners of the premises would be entitled to deny access to anybody who is seeking to deliver a assisted dying service in their premises. They would be entitled to prevent that from happening, yes. Obviously, it's an extremely unlikely scenario. Nevertheless, it's one that I think we need to contemplate. And to his point that, and I thank him for his clarification, I'd understood that he had acknowledged that it would be appropriate for the management of a Catholic care home to specify that there shall be no assisted dying on these premises, but he's suggesting that there shouldn't be, it would be illegal, inappropriate, I'll give you in a second, for the management to make that stipulation. It just wouldn't happen organically because nobody would want that in that place. Well, I regret that because I think it should be appropriate for the management of a place to say, not in some sort of vindictive mission to deny people some particular right or service, but to convey to everybody else who lives there that this is, as it were, a safe space in which there will not be, state-assisted suicide. And I think that's a reasonable hope and expectation that many residents will want when they come to live in a certain place. Once this becomes normalised, once it becomes, 5–10% of deaths, as happens in parts of Canada, if this becomes a normal and standard way to live, way to die, then I think there will be many people who don't want to live in communities in which that practice takes place. I'm afraid we are going to find a demarcation, a bifurcation in society among those for whom they do not want to live in a assisted suicide community. And it would be appropriate for them to have the option of going to live in a place where they know that that will not be taking place. I do concede, by the way, there are many of the institutions that we're imagining here, these shared communities, where, of course, it would be perfectly appropriate and understandable for it to be an option for residents there. I mean, I think of, and thinking about the different sorts of places we're talking about. I mean, there's the Duchess of Somerset Almshouse, in my constituency, the sort of place we have in Wiltshire. A lovely place, beautiful. And it's got lots of Liberal Democrat voters in it, because I knocked on all their doors. And I can imagine, they were unfortunately the wrong sort of Liberal Democrat, and I can imagine many of them supporting the right in their home, behind their own front door, which they have there, to have an assisted death. And I'm sure that the other residents of that place would concede that that's appropriate. But then there are other places in my constituency, and a hospice being the most obvious one, where neither the management nor the other residents would be comfortable. In fact, they'd be extremely uncomfortable with the sense that assisted suicide might be practiced in the next door room, and whether it's performed, as it were, by the hospice staff or merely facilitated by them. And it would be extraordinary if it was somehow to take place without the facilitation of the staff that manage the facility and look after the patients, to have this take place as some sort of parallel track. I think that would be an extreme imposition on that hospice, on the management of that hospice, and it would be extremely disquieting for everybody else who lives and works in that place. So I think it is an appropriate consideration to give these places the right, at a management level, to opt out. And Madam Chair, I want to express my deep concern about what we heard from the Minister, his suggestion that we should not give either individuals or institutions the absolute right to opt out from the facilitation of assisted suicide because we think that the ECHR, the European Convention on Human Rights, will present a challenge to that a court in this country, or indeed in Strasbourg, would overrule any decision by in fact, they would negate this law. They would challenge this law if we passed it with these amendments to protect hospices and individuals, that we would then have a court citing international law to attempt to overturn this law. I am very concerned about that, both in terms of parliamentary sovereignty, but also in terms of the government's own position. Surely, if the government thinks that it's the right thing to do, we should do it, even if we fear an ECHR challenge. I think that's I'm afraid to say, a craven submission to a lawmaking body that is not sovereign in our country and would only be advisory. So I regret what he said, and I hope maybe the Minister in her subsequent remarks can, the Justice Minister can clarify that the government would not concede an ECHR challenge if this Parliament decides to insist on individuals' rights to decline to participate in assisted suicide. And the Honourable Lady, in response to my challenge on that point, suggests that that's an interesting topic for future conversation. I'm afraid this is the moment to have that conversation. We're deciding on amendments now that will insist on people's right to decline to take part in assisted death. And there will be no further opportunity except at report stage, which will be a limited opportunity, in which we can insist that people do have this right to opt out. Now, the second objection, coming back to a remark made by the member for Luton South yesterday, which was an interesting one that hadn't occurred to me, I'm afraid, which was whether a husband could legitimately deny his wife or whatever, a partner living in a home, their own shared home, the right to assisted suicide in their home. And it's a very good challenge. It's certainly not the policy intention, as I'm sure she appreciates, to enable that sort of, one partner to deny the other one the right to assisted suicide in their shared home. So I ask her to accept that's not the intention, and the purpose of the amendment is to give the right of an occupier to refuse assisted dying. So what I propose is, with her permission, given that this clause will only be voted on next week, to retable a clause that will address the concern that she made, and I'm very happy to work with her or with government to get to the point where we're satisfied that that concern has been addressed, because of course she's absolutely right. If it's your own home, I think you shouldn't, your partner, the person who shares the home with you, shouldn't be able to deny it. We've also discussed the question of which protected characteristic in in relation to Amendment 481. I think actually perhaps we've hashed over that whole question about protected beliefs. So I'll move on from that. I'm happy to be ready.
With the difference between my own home with my partner and my care home with lots of people that may or may not be strangers, and why I should have the right in one but not in the other.
Well, my right honourable friend, I hope, will understand there is a difference between occupying your own home and living in a community where you do live under conditions set by somebody else, which is what you do if you live in a care home. There are terms and conditions that apply. You have to comply with the rules of the place. You have obligations to your fellow residents, whereas if you're in your own home, whether you're living with a partner or not, you have, as it were, absolute rights there. And that's the difference. So if you sign up to go and live in a care home, just like if you go and live in a hotel, you have to follow the rules of the place. Whereas in your own home, you can do what you like. I'm sure the honourable gentleman does. Happy to give way.
I would wonder, I think we should acknowledge the reasons why people go into residential and nursing care homes. They go into them because they need help to live. They need help from day to day. I would wonder whether he would reconsider what he's just said, because that does seem to discriminate fundamentally with those people who are able to live at home, have families around them, have carers around them, can operate in that way, and those people who need to go into residential or particularly nursing homes.
I'm afraid, I'm grateful to the Honourable Lady. She clarifies the point very well, and I'm going to concede. That is right. When you go and live in a care home, you are yielding up, of necessity, a whole set of freedoms that one has in one's own home, and that is the consequence of the stage of life you're at, the conditions you have, and indeed your own choice to go and live in that particular care home. Well, I appreciate that. There might be very little choice. There might be no alternative. But that is, Madam Chair, I'm speaking in terms of the reality of life here. And yes, we can do everything we can through the law to, as it were, obviate reality, to give people additional, as much autonomy as possible, even though they are themselves very dependent on other people. That's why it is so important to consider the autonomy of the elderly and the frail, people who with disabilities or who are ill, because they do require other people to give them what fully healthy and able-bodied people are able to do for themselves. So I do recognise that what I'm suggesting is that somebody who lives in a care home would not have the same freedom of action as somebody living in their own home. That is,
Order. It being 11:25 a.m., the committee is now adjourned until 2 p.m. Order.